Thank you so much for joining us for the second half. We call this Next Up. Bill McClellan and I will be talking, as we always do, Thursday at this time, to community leaders about important topics. And this is really a topic that you're going to be talking about for quite some time. It's probably going to generate some real discussion around your household. We're so lucky to have some great guests with us, starting with Professor Kenya Brumfield-Young from St. Louis University. She is a professor of criminal justice. And we thank you very much for joining us.
Thank you for having me.
We welcome back to Next Up Mike Wolff, former dean of the St. Louis University Law School and also former Chief Justice for the Missouri Supreme Court. Thank you very much, Mike, for joining us.
Nice to be here again. Thank you.
And with us now via Zoom is Christopher Dunn. Ms. Dunn is really at the center of this case, and here's the deal. Christopher Dunn was found guilty of murder 32 years ago, and he's been in prison since. But since then, the two witnesses whose testimony led to his conviction have recanted their testimony. They said, no, what they said was not true. And a judge in Texas County, Missouri, agreed, and he said, look, under the facts that we have today, this man would not be convicted in a modern court. And yet, Christopher Dunn, thanks for joining us. Your husband, Christopher, is still in prison and can't get out. Thank you so much for joining us on Next Up. How are you?
I'm doing all right. So pleased to be here. Thank you.
Yeah, so explain this to me. The two witnesses in this case recanted their testimony. It was their testimony that led to your husband's conviction. And yet the judge says there's nothing we can do under Missouri law.
That's correct. The two witnesses did recant. They explained that they decided to say my husband was the guilty party just because they didn't like him. And once they identified him, they kind of felt they had to double down on it. And in addition to their recantations, however, we also had an independent witness who was never interviewed by either side, who explained, along with what the witnesses said, no one could have seen where the shots came from that night. And in addition, my husband was on the phone at the time of the crime. The young woman he was on the phone with was able to come to that hearing that you referred to, as well as another witness who'd heard the first eyewitness say, well, you know, I'm getting a deal for it and I don't really care about Dunn, so I'm just going to say it was him. So all those things were brought to bear, and that is what led to the judge saying, as you said, based on these facts, no jury would now convict Christopher Dunn.
And this murder that did happen, committed by someone, took place May 15th, 1990 in the Wells Goodfellow neighborhood of St. Louis, correct?
May 18th, actually, but yes.
Okay.
Around midnight in the Wells Goodfellow neighborhood. A group of young boys was sitting on a porch, socializing, when suddenly shots came out of the dark. They all scattered, one fell and did not get up. So from that point on, it didn't take long till the two said, we think it was Christopher Dunn. He was arrested the next day and was held in St. Louis County Jail, well, city jail, for a little over a year before he was tried. He had a public defender who was quite overloaded by the looks of it, met with him maybe a total of 20 minutes before she represented him, and really didn't bring any of his alibi witnesses. He had 7, in addition to the person he was on the phone with. Didn't bring any of that to court. Even so, the state also did not bring any evidence to court against him except the testimony of those two young boys, 12 and 14 at the time. Initially, the state offered Chris 10 years to admit he did it. To my understanding, a prosecutor doesn't do that if they have a particularly strong case. He refused, then he was offered 20 at a later point. He refused and ended up being sentenced to life without parole plus 90 years. In 42 minutes, I should add. The jury deliberated for 42 minutes before they came to their conclusion.
Say, Kira, why don't you tell the viewers exactly how you met your husband and what circumstances?
I met Chris in 1999 when I was volunteering as a staff writer and editor for an online magazine called Justice Denied. Justice Denied would you'd generally be approached with a story. We would vet it to the best of our ability, and if it seemed to have merit, we would put it out in the magazine in hopes that perhaps a pro bono investigator or attorney might assist. And there were some success stories. So when I was assigned Chris' story, I took a look at the documentation, talked with his prior attorneys, his family, and him, and I was struck right away by the fact that what the witnesses said, the two young boys, in their police interviews was markedly different than what they said at trial. Mm-hmm. And from there, I looked into it, and yeah, I was convinced pretty early on that Chris had a very strong case of innocence.
And where is he as we speak right now?
Currently, he's at South Central Correctional Center in Licking, Missouri, about 2 hours south of St. Louis.
Mm-hmm. You know, now one of the young men who's recanted, DeMorris Strepp, I think it is, he's doing life without parole for a murder. And when a fellow in prison recants his testimony in a trial, there is a certain amount of skepticism about the recantation because, you know, having a reputation in prison as someone who testified against somebody else isn't a good thing, but helping somebody get out would raise your stature, I'm told. So I don't know anything about the other young man. I didn't have time to look him up because he's got a more common name. Do you know what have you ever met Michael David, the other young man who's recanted?
Our investigators have had direct contact with him. So through them, I've heard the audio that he provided. We do have that. So he also led a rather troubled life. By the time when we did contact him, he was in jail for a drug offense here in California, and would have appeared at the hearing, but had gone into drug treatment and checked himself out of the program early. However, we did provide the audio. We provided his notarized statements, and the judge was satisfied with that at the time. But you're right. I know some people do tend to take a dim view of, you know, jailhouse informants or not, you know, who especially those who recant and wonder what could the benefit be. I don't see that there was one. I feel that from what I've seen, it can actually make you look like a bit of a rat, that you, to use that term, that you put someone in prison, to admit that openly. However, in our case, and I think when Judge Hickel wrote, he said, given that petitioner has an alibi, this court now believes that no jury would convict Christopher Dunn under these facts. So that independent witness, and well, multiple, but particularly one who was there at the scene and was an eyewitness, was instrumental in us being able to convince the judge of Chris's innocence.
Well, it seems like there's enough information for a sort of legal do-over. Mike Wolff, you're not only the former dean of the SLU Law School, but you actually sat on the Supreme Court when a case relevant to this one was discussed and decided upon.
Well, the case that you're referring to is Amrine. Joe Amrine was in, and he had the witnesses against him over time, because all of these cases go on they go through state review on appeal, and they have appeals, and then some of them go to federal habeas corpus, and so there'll be multiple proceedings, as there are in Christopher's case, and so that when you get down to it, in the Amrine case, the witnesses had all recanted, except for one. It was a prison, the guard in the prison always said it wasn't Amrine. So the Supreme Court, when I was on, put two and two together and said, granted, what you do is you grant a new trial. And the prosecutor says, well, there's no evidence, so I can't retry him. Actually, some months later, or a couple of years later, I met Joe Amrine. He was on the speaking circuit talking about what it's like to be wrongly convicted, and he was wrongly convicted. Then what happened was that that was 2004 approximately. 2016, the Court of Appeals over in Kansas City had a case very similar to this with recantations and so forth, but it wasn't a death case. It was not a death penalty case. And so that court said, now what the Supreme Court said only applies to death penalty cases. So you can be innocent in Missouri in prison, but if you're not under a death sentence, you can't get out the way that this process is set up. And that, of course, makes no sense. In fact, there have been 2 cases where the Supreme Court of Missouri appointed a special master to look at the facts, because these are all on something called habeas corpus, which always comes up later. It's a writ that's been around for hundreds of years, and the special master is the one who takes the evidence. In 2 of the cases, the special master, who are usually senior judges of some kind, said, this makes no sense. That this only applies to death penalty cases.
So in layman's terms, Professor, you can only have a do-over in one of these cases if the death penalty is involved.
That's correct. And that's correct. And that's one of the conversations that we've had around this is how are we metering out, equal justice under the law if we're saying that these are 2 different classes of people, right? That your extension or your claim of innocence only applies if you're on death row. Are you any less innocent if you're not on death row? And so that's been part of the discussion point around all of this issue is why should it only apply when if someone is making an actual claim of innocence that their status is changed because they're not on death row. And that's the big conversation around this at the time is we shouldn't have people who are sitting in prison with evidence to either have a new trial, have their conviction vacated, or to be just exonerated altogether because they have the wrong status or because they're not on death row.
Well, let me bring up something philosophical here. Aside from actual innocence, what about the cases, which I think the majority are, where we can't expect somebody to prove their innocence from prison, but just that, hey, a jury today, like in this case, or Lamar Johnson case, where a judge looks at it and says, a jury today, knowing what we know, would not convict this person, but that he's not necessarily innocent, but he could not be proven guilty beyond a reasonable doubt. Is that where we should be going?
That is where we're going, and that is now the problem, of course, is that if you just have a freestanding claim of innocence, and that's all, the only thing you've got to show for yourself is that you're innocent. You don't get any relief if you're not unless you're on death row. However, if you can show that there's a constitutional violation, that they hid evidence contrary to the cases from the U.S. Supreme Court, then you can get in and show that it's unlikely that you would be convicted on retrial. Yeah, so you can get relief some of the time, but not in Christopher Dunn's case.
But what do other states do when it comes to freestanding claims of actual innocence? If this case, the Christopher Dunn case, was in New York, Mississippi, or California, would he have a do-over? Would there be a mulligan?
He might very well, and in most states they have a much more, and this one really stands out. There's a lawyer in New York State who's representing Christopher, who is taking this on appeal, on a petition for certiorari to the U.S. Supreme Court.
Correct. About
Missouri being the state where you can be innocent and still be held in prison. And I think he's done a pretty interesting job there. And actually, most of the time when you ask the Supreme Court to hear a case, they say no. They've got 12,000 or 15,000 cases a year, and they take about 100. In this case, they asked the state attorney general to respond to this. So there is maybe some movement on that. I remember in the Amrine case, when the case was argued, the attorney general's office made the argument that he got a fair trial. There were no constitutional violations. And so therefore, he had to stay in. And 2 of us judges asked, well, what if he's innocent? Do we have to execute him? And the answer was yes.
And
that's pretty sobering.
It's horrifying. I mean, that's absolutely horrifying. Missouri has a very narrow window for, actual claims of innocence as well as newly discovered evidence. We're only allowed so much of a window right before the jury decides or after the jury decides, but it's a very small window even of bringing in even new evidence that can exonerate people. So we have very small windows in regards to either, actual claims of innocence or even bringing in new evidence that could exonerate people.
But you would think, especially in the post-DNA world, where we have found that many people have been put on death row for crimes they could not possibly have committed, we found out later through DNA evidence. You would think that people would say, okay, maybe the legal system isn't perfect all the time, so why not in Missouri have some sort of mechanism so that if you can accumulate a lot of evidence, get your ducks in a row, cross your T's and dot your I's, you can have another day in court.
But the counter to that is that at some point a judgment has to be final. So you have this tension between finality and correctness. And I think oftentimes you find the state erring on the side of being final. Whatever the result is, we had a jury trial, it's been affirmed on appeal, all of that, and so we're done. So that's the counter to that.
I think Kira Dunn wants to get back into the conversation. Ms. Dunn?
Yes. Yes, and what so many things what you're saying, I'm just nodding in agreement here, and it is sobering that, you know, I believe, and not speaking from a place of authority here, but from what I've observed, the Missouri AG's office is really interpreting their mission as maintaining convictions, any conviction, regardless of evidence, regardless of findings, but, you know, and it's so frustrating to, as you noted, know that in Missouri, this is a pretty unique situation we're facing here. If it had happened somewhere else, my husband would be home playing with our grandchild and getting cardiologist care and the things that, you know, he simply cannot do until this is resolved.
By the way, for the record, I personally called and texted, rather emailed the Attorney General's office to see if a representative would like to join us for this program. Did not hear back.
You know, now, there are prosecutors who would make the argument that if you allow these recantations to let somebody out, that they already have such a difficult time getting witnesses to testify because people are frightened, and they say, hey, if you just testify, we'll put this person away, and that if all of a sudden recantations will get somebody released, the witnesses, you know, it's not just protecting them until the trial. What, you know, 2 years afterwards, 5 years, somebody might be coming up to them and go, hey, we want you to recant. Just say the police pressured you and get the, you know, I mean, the argument for some kind of finality is an argument.
And that's one of the things in Judge Hickel did a very careful job of going through the evidence. In fact, this one witness, the 15-year-old, the 14-year-old, who recanted, basically told about 2 or 3 different stories. And the basis for the judge saying that you couldn't convict Mr. Dunn on this testimony was that this guy told 3 different stories. The other guy, I think, simply recanted, but he's not available. He went on the lam after he left the drug treatment program. And then the witness that did help, as Ms. Dunn mentioned, is the guy who was there, who wasn't called at trial, but who said it was so dark you couldn't see anything. You couldn't see who was shooting. And so the eyewitness, and eyewitness identification is a fairly common way of getting wrongful convictions. Eyewitnesses are not terribly reliable, but judges know that, and I think Judge Hickel was experienced enough to figure out, is this a case where they're just, you know,
well,
junk or not, right?
Now, Mike, you say that eyewitness testimony is not terribly reliable, but there are experts like Dr. Elizabeth Loftus of UCal Irvine, who's had a whole career pointing out how none of us have very good eyewitness testimony to anything. I mean,
Absolutely.
You know, it's certainly true for umpires at Cardinal Stadium, but the rest of us, if somebody walked in here right now and walked across this stage, we may say that his jacket was black or brown, he was 5'10" or 6'10", we would all have different stories. And so in this case, the conviction relied on 2 kids, 12 and 14, in the dark, and they didn't listen to the alibis of the other 7.
Well, and often with recantations, they want some evidence to support. The court isn't, along as with a confession, there's got to be some sort of evidence. It can't just be someone just changed their mind, right? Because as the way you just mentioned, then everybody could just go in and say, oh, I've changed my mind. This is, oh, never mind. Well, we have to do better. These are supported. So when they're supported, then of course they have more weight. So those are other factors that come into consideration when we're speaking about witness recantations. Is there enough evidence to support these recantations, and can we show, because the other question that's going to come up even in a hearing is, was a witness being untruthful then, or are they being untruthful now? So you've got to have something that's going to support whatever the recantation is.
And some of them, the evidence was just wrong or bad or whatever. There's a case coming out of Washington County that the Supreme Court of Missouri heard on the petition of the Attorney General to try to limit or get away from the statute that the legislature passed the year before last to allow the prosecutor to make a motion when the prosecutor believes that there's been a wrongful conviction. And in that particular case, this guy was convicted of murdering his mother by burning her up. And the only physical evidence against him was testimony of somebody who said there was gasoline on his shoes. Well, then they looked at it some years later. There wasn't any gasoline. There wasn't any. The testimony, the science, it was junk science. It was false. So you've got a guy in prison, and that's the testimony, or that's the evidence that put him there. So you have to have a way to do this.
And to that, I mean, this is also something our legislature can fix. They can pass the bill that says we're going to expand, freestanding claims of actual innocence to people who are beyond death row. I know that's been submitted this session, but there is a way for us to allow the court to correct itself. So this isn't something that is just completely unfixable, and we have to hope that the court overturns itself. The legislature has the power to correct this or to re-steer the show.
Do you think there's much of a chance, Kenya, like if you've been talking to legislators or people in the movement talking to legislators about getting this done?
Well, I know that HB 360 has been filed, so I don't know what kind of traction it's getting, but I know that there's some conversation there, and I hope that people see that this is an issue. It's not a left issue. It's not a right issue. It's just an issue.
In the statute that was passed the year before last to allow the prosecutor to go back into court and ask for the conviction to be set aside, it's very specific about the standards. You have to show by clear and convincing evidence that there was a wrongful conviction. But you have to understand that the Missouri legislature, both houses of the General Assembly, dominated by conservative people, a bill signed by the governor, a conservative guy who was a former sheriff, and that bill was also had the participation and support from the Missouri Prosecuting Attorneys Association. And what you have to say is nobody wants an innocent person to be in prison. If you're in favor of that, then there's something wrong with you. And I think that the legislature realizes that. I think the governor realizes that. I think the parole board realizes that. I think the public understands that as well. We're not a perfect system. We make mistakes. But most of the time, thankfully, we get it right. So
well, and of course, we're expanding it from proving innocence to just wouldn't be convicted today. I mean, because there's a big difference between somebody who has to prove their innocence and somebody who has to just show that if I were put on trial today, I wouldn't be convicted.
Well, the standard that we have in court for your original trial is it true beyond a reason, you believe belong to reasonable doubt, the evidence of his guilt.
Right.
Well, that's still the same standard. We don't, in fact, when I was in the newspaper business 100 years ago, we used the word innocent when the legal term is not guilty. And the reason we did that is we didn't want to be sued for leaving out the word not. So innocence is really, the question is really not guilty.
Right. That's really what I was trying to get at. Mm-hmm.
So what is the hope then for this man? And maybe, Ms. Dunn, we can bring you back in here too. I don't think you're probably too optimistic about a legislative fix with this General Assembly, but who knows? It's possible, right? Are there any other avenues that might help your husband?
There are. As you noted, if this became a bipartisan effort, there's hope. And if I could hark back really quickly to what you said, yes, a finding of guilt is enough to take away someone's freedom in our current court system. So why isn't a finding of innocence enough to restore it? Along, as the judge said, reasonable doubt. In any case, another path that we're hopeful, I believe Judge Wolff mentioned that we are currently have a petition in front of the Missouri Supreme Court declined to hear it. So we're now with the U.S. Supreme Court. As you noted, the state's been asked to provide a response by February 6th. So we're hopeful that it might be taken up. The other avenue would be through what was formerly Senate Bill 53. Now it's Missouri Statute 547031, which people know as the Prosecutor's Empowerment Bill. Mm-hmm. This allows prosecutors to correct a wrongful conviction that comes to their notice if it happened in their jurisdiction, and it is directly tied to what's going on currently with the Missouri Supreme Court with Michael Polite. And that is often really not that strong of a hope for us either, seeing how the AG's office comported itself in Lamar Johnson's hearing. I mean, even the judge became impatient with the way they disputed every fact and didn't seem to really focus on the issue at hand, which is innocence.
Kira Dunn, I'm sorry to say that our time has run out, but we want to thank you very much for joining us on this edition of Next Up. Thank you. Also want to
thank you so much.
Thank you, Dr. Kenya Brumfield-Young from St. Louis University. Thank you very much.
Thank you again.
Judge Wolff, thank you very much.
Nice to be here. Nice to see you.
And thank you, everyone, for joining us for this edition. You can always get these on your favorite podcast as well. Thank you very much.
Donnybrook is made possible by the support of the Betsy and Thomas Patterson Foundation and the members of 9PBS.